Just because you have the capability as an attorney to do something does not mean you should be the one doing it. Think about what your calendar would look like if you learned to delegate appropriately. Not abdicate, delegate with confidence, with the right guardrails in place, in a way that protects you, your practice, and your work product. Today, we look at how to build those guardrails. And along the way, and what I believe is one of the most important business distinctions ever drawn for professionals running their own practice. The distinction between someone who works in their business and someone who works on it. You do not want to miss this. I am Robert Bunn. This is Estate Planning for Lawyers. Quick housekeeping before we dig in. Nothing in this podcast is legal advice, and no attorney-client relationship is created by listening or watching. There's a full disclaimer at the end. If you are listening on Spotify, Apple Podcasts, Amazon Music, iHeartRadio, or another audio platform, thank you. Along with those of you on YouTube, I'm glad you're here. If you're listening on audio, I would suggest you take a moment and subscribe on YouTube as well, because the video adds another layer to the conversation. And if any of this is useful to you, please consider sharing this with another attorney who you believe may benefit. The authors Mark Powers and McNalis of the book Time Management for Attorneys, A Lawyer's Guide to Decreasing Stress, Eliminating Interruptions, and Getting Home on Time, published by Atticus, argue in Chapter 8 that the ability to delegate effectively is the difference between an attorney who has a job and an attorney who has a practice. The authors lay out the specific skills, mindset shifts, and tracking systems that make delegation actually work. And they confront honestly the internal resistance most attorneys feel when they try to let go of work they have long done themselves. Now let us dive in. In the prior episode, episode 9, we worked on managing interruptions. We talked about the math of lost time, the allowable interrupters list, the closed door, the legal pad, and the self-interrupting attorney. The central argument of that chapter was that an attorney's bandwidth is their most valuable asset, and that protecting it is non-negotiable. This is the natural next step. Once you have protected your bandwidth, the question becomes what to do with it. Powers and McNalis argue that the answer is leverage. The attorney who spends their bandwidth on work that does not require a law degree is wasting the asset they just spent the prior chapter protecting. Delegation is what turns that asset into something larger than the attorney themselves. Powers and McNalis, they open the chapter with a diagnosis they call self-enhancement bias. Self-enhancement bias is the tendency of attorneys to believe that nobody else in the office can do their work as accurately or as quickly or as well as they can. The authors are clear that in some cases, this belief is correct. There is work that genuinely requires the attorney's special skills, the attorney's experience, and the attorney's law degree. The problem is not that attorneys ever hold work back. The problem is that attorneys hold back almost all of it, based upon a bias rather than an honest analysis. Powers and McNalis observe something that I think is worth pausing on. The same attorneys who believe they cannot delegate often have a story they tell about why. The story usually involves an assistant, a paralegal, or an associate who was given an assignment, and the assignment ended in disaster. The attorney's takeaway from that experience is, I cannot trust anyone with my work. The authors push back on that conclusion. They point out that what happened in that disaster story is usually not delegation at all. It's abdication. The substantive work was handed off with no real guidance, no training, no meaningful support, and no review at the end. The bad outcome was a predictable result of the way the work was handed off, not a verdict on the person who received it. That is a distinction worth sitting with. Abdication looks like delegation, but it is not delegation. Real delegation involves training, context, tracking, and review. When attorneys say they have tried delegation and it has not worked for them, the honest follow-up question is whether what they tried was delegation or whether what they tried was something that wore the same clothes. The authors lay out what real delegation requires, the willingness and the ability to do 5 things. First, Identify the parts of the case that genuinely require the attorney's special talents or the attorney's law degree to handle. Second, trust that others can be trained to assist in delivering high-quality service. Third, analyze workflow and identify which tasks belong outside the attorney's hands. Fourth, set up a system to track delegated tasks. Fifth, provide specific training, information, and context when delegating. All five are necessary. The authors are emphatic. Delegation without any one of them is the thing that gets attorneys back to the abdication story. Powers and McNalis offer a metrics for diagnosing whether you are well leveraged. The metric is a ratio. Attorney time per file relative to staff time per file. The lower the ratio, the more leveraged the attorney. The more leveraged the attorney, the more profitable the practice. Because profit in a law firm is the gap between what the work costs to produce and the work bills out for. An attorney whose time fills the entire file is producing every billable hour at the most expensive rate in the office. An attorney who has delegated the work that does not require a law degree to lower cost team members is producing the same file at a lower cost basis, with the attorney's own time freed up to take on more matters. The authors include a pull quote in this section from Charles Percy, who was the president of Bell and Howell and later the United States Senator. In his own words, Percy said he had been so consumed by work that he should have handed work out to others that he lost the time he needed to actually manage. I want you to sit with that one for a moment. An attorney who is buried in work that does not require a law degree is not managing their practice. They're running on a treadmill inside their practice. The treadmill moves fast. The treadmill produces output, but the treadmill does not take the practice anywhere. I want to step outside the book for a moment to introduce a related idea that, when I first encountered it, fundamentally changed how I think about what I do. The book is The E-Myth Revisited by Michael E. Gerber. There's also a vertical edition co-authored by Gerber and others titled The E-Myth Attorney, which applies the framework specifically to law practice. Both are excellent. Gerber's core insight is this: most small businesses are not started by entrepreneurs. They are started by what Gerber calls technicians. A technician is someone who is very good at the technical work of a profession, a skilled carpenter, a skilled chef, a skilled attorney. At some point, the technician decides that they would rather do the work for themselves than for someone else, and they start their own business. The mistake Gerber identifies is what he calls the fatal assumption. The fatal assumption is that being good at the technical work of a profession means you will be good at running the business of that profession. Those are two completely different skill sets, and most technicians do not realize this until they are already inside the business, doing every part of it themselves, and wondering why they have less time and less freedom than they had as employees. Gerber argues that every business owner is actually three different people in tension with each other. The technician, who's happy is doing the technical work. The manager, who plans, organizes, and builds systems. And the entrepreneur, who sees the future and sets a direction. Most business owners, Gerber estimates, are roughly 70% technician, 20% manager, and 10% entrepreneur. That ratio is a source of nearly every problem the chapter we are working through today is trying to solve. The attorney who refuses to delegate is the technician winning the internal argument. The manager and the entrepreneur lose, and the practice plateaus. Gerber's famous formulation is one I want to give you, because once you hear it, you cannot unhear it. The successful business owner works on their business, not in it. Working in the business means doing the technical work, drafting the will, negotiating the contract, reviewing the document. Working on the business means building the systems, training the team, choosing which matters to pursue, and deciding what the practice is going to become. Powers and McNalis are making the same argument Gerber is making, but in the language of delegation. The attorney who delegates well is the attorney who has carved out time to work on the practice, instead of being permanently stuck in it. Powers and McNalis return to the practical question of how to actually do this. They start with a concept I find both gentle and useful. The authors call it levels of trust. The point is, delegation does not have to be an all or nothing decision. The attorney does not have to choose between doing everything themselves and handing over complete autonomy. The authors describe 4 levels of trust the attorney can institute, and each level can be matched to a different task or a different team member. Level 1 is bring the facts to me and I will decide. The team member gathers information and presents it. The attorney makes the call. This level is for new team members who are still learning and for the highest stakes decision. Level 2 is recommend alternatives and I will decide. The team member does the work of gathering and also of analyzing, presenting a small set of options. The attorney chooses among them. This level is appropriate for staff members or junior associates who are developing judgment. Level 3 is you decide and you report your decision to me. The team member exercises judgment and acts, and then loops the attorney in afterwards. This level is appropriate for more experienced team members whose judgment the attorney has come to trust. Level 4 is you decide, no report needed, full autonomy. This level is appropriate for partners, for senior staff with years of demonstrated judgment, and for tasks that fall clearly within team members' area of responsibility. The authors make the point that different tasks, even within the same matter, can be delegated at different levels. The level 4 task does not have to wait until you have a level 4 employee. You can have a single team member operating at level 1 on a complex client matter and level 3 on the routine intake process. The levels are a tool, not a label. Powers and McNalis then offer what I think are the most useful framework in the chapter for deciding what to delegate in the first place. They call it the risk/complexity matrix, and they credit it to the Institute of Management and Administration's Law Office Management Report from the year 2000. The matrix is simple. Every task falls somewhere on 2 axes. Risk, meaning what happens if the task is done badly, and complexity, meaning how hard the task is to do. The 4 quadrants are these: low risk, low complexity. Writing a routine letter, delegate it fully with a brief final review. High risk, low complexity. A task that is not complicated, but that has significant consequences if it goes wrong. Delegate it with very specific instructions and schedule ample time to review and correct. Low risk, high complexity. The kind of multi-step work where mistakes are recoverable, but the work itself takes skill. Break it into chunks. Delegate the simpler chunks. Keep the more complicated pieces for yourself. High risk, high complexity. The kind of work that genuinely demands the attorney's attention. Even here, the authors recommend breaking the task into smaller pieces, delegating what can be delegated, and using the remainder as a training opportunity for the team. And then Powers and McNalis add a 5th dimension that overrides everything else: recurrence. If a task is going to recur in the practice, it is worth the time to train someone else to do it, even if the training takes longer than just doing it yourself the first time. Because the training is a one-time cost, and the recovery of attorney time is a benefit that repeats every time that task comes up again. If a task is genuinely one-off and will not recur, and explaining would take longer than doing it, then do it yourself. The authors are clear that this is the exception, not the rule. Most attorneys, under the influence of self-enhancement bias, classify too many tasks as one-offs, when in fact they are recurring. The authors recommend being honest about this. I want to spend a moment on something the authors call the designated hitter, because the term comes up repeatedly in the book, and chapter 8 is where it gets its fullest treatment. The designated hitter is the person on the team who serves as the attorney's primary delegate. Powers and McNalis describe the designated hitter as typically a paralegal, but the role can be filled by an associate, a legal assistant, or a senior administrative team member. The defining characteristic is not the job title. The defining characteristic is the combination of technical capability and what the authors call a sympathetic ear for clients. The designated hitter does several things. They make proactive check-in calls to clients so the client feels attended to without the attorney being on the phone. They handle incoming client calls, answering routine questions, and escalating only the questions that genuinely require an attorney. They build rapport with clients so that the relationship with the firm is broader than the relationship with one human being. They handle parts of the intake interview. They keep referral sources informed. The authors include several sample scripts in the book for how to introduce the designated hitter to clients. The framing the authors recommend, paraphrased in my own words, goes something like this. The firm operates as a team. This particular team member is going to be deeply involved in the client's matter. In many day-to-day situations, this team member will be more accessible than the attorney. The client should feel comfortable directing routine questions of that person, and the attorney remains the point of contact for anything that requires legal judgment. The authors recommend that you tell the new client directly that the designated hitter's billing rate is lower than yours, and that the client saves money when they direct questions to the right person. Said out loud at the first meeting, that single sentence reframes a relationship. The client no longer feels like they have been handed off. The client feels like they have been given access to a more affordable team member. Powers and McNalis include in this chapter a case study I want to highlight because it is set in Florida and because the attorney profile is doing something genuinely impressive. The case study features Richard West, a family law attorney in Orlando. At the time the book was written, Mr. West was serving as chairman of the family law section of the Florida Bar. The authors describe his practice as the closest to paperless that they have personally encountered. The system Mr. West uses has two parts. First, every piece of incoming mail is scanned to his computer system by an assistant. The paper itself becomes secondary. The digital file is what the attorney works from. This also lets him review his mail from anywhere, not just from his office. Second, Mr. West uses what the authors call desk management. He maintains two specific drawers in his desk. One is an open file drawer, which serves as a staging area. When a client walks in unexpectedly, or when he needs to pivot to something else, he simply drops the files he is working on neatly into the drawer. The desk is clear in seconds. The work is not lost. The other drawer holds frequently used files, accounts receivable, articles and lectures he's working on, committee chair lists, phone numbers. He also keeps a separate file folder for each staff member. Anything that needs to be discussed with a particular person goes into that particular person's folder. When he meets a staff member, he pulls a folder, and the meeting covers everything at once. Batch delegation. No items missed, no items forgotten. And finally, Mr. West clears his desk at the end of every day. I find that case study genuinely instructive. It is also, I will note, the kind of practice infrastructure that I aspire to. The Florida State Planning Bar has, in Richard West, an example of what the systems we are discussing across this book actually look like when they are fully built out. Powers and McNalis spend the rest of the chapter on the mechanics of tracking, training, and ensuring the delegation actually works in practice. On tracking, the authors recommend what they call the delegation file method. One file per person you delegate. A scheduled meeting time with each person, usually 15 to 30 minutes before your production block. A written delegation form for every task with a copy in the file. At the next scheduled meeting, you pull the file, review the prior tasks, and use it as the agenda. Nothing falls through the cracks. On training, the authors are emphatic that delegation without training is an abdication scenario in disguise. Train through formal CLE attendance, train through job shadowing, train through buddy systems, train through weekly internal sessions, and most importantly, train through what the authors call just-in-time training. Every time you delegate, take a few extra moments to explain the context. Every time you review work, take a few extra minutes to explain what could have been done better. That cumulative investment and feedback compounds over months and years. The authors include a full quote in this section from Aga Hassan Abidi. The quote reads, The conventional definition of management is getting work done through people, but real management is developing people through work. I think that is one of the most important lines in the book. Delegation done well is not just leverage. It is a way of developing the people on the team. The work they do today with your training and your feedback is what makes them capable of doing harder work tomorrow. The investment compounds. The chapter closes with an acronym that summarizes the entire approach. The authors call it the SMART rules for delegation. And I want to give it to you because it is, in my view, genuinely useful as a checklist for any delegation conversation. S stands for specific. Be clear about what is to be done. If the task is unfamiliar to the delegate, be very specific in writing if necessary. M stands for measurable. Establish what the outcome should look like. Quantify where possible. Ask the delegate to repeat the expected outcome back to confirm understanding. A stands for accountable. Choose a delegate who will take ownership, communicate progress, and surface problems rather than hide them. R stands for realistic. Build in checkpoints. Allow time for learning and mistakes. Provide adequate resources. Do not delegate something that cannot actually be done in the time given. T stands for timeline. State the deadline clearly. Include checkpoint dates. State the consequences of missing the deadline. Remember that the first time a task is done, it takes longer than it will the 10th time. Specific, measurable, accountable, realistic. Timeline. 5 letters, 5 rules. Every delegation conversation can be checked against them. Before we go further, an important caveat. Nothing I have said in this episode should be heard as a suggestion that you relinquish supervisory oversight over the people working with you or under you. Every state's rules of professional conduct impose non-delegatable duties on supervising attorneys. The supervising lawyer remains responsible for the work product, the client relationship, and compliance with the rules. Whether the work was done by the attorney personally, by an associate, by a paralegal, by a contract assistant, or by anyone else on the team. What we have been talking about today is leverage, not abdication. Delegation done well preserves your oversight. Delegation done badly compromises it. The systems Powers and McNalis describe the levels of trust, the risk and complexity matrix, the SMART rules, all exist to keep oversight intact, while the work itself is performed by the right person at the right level. Please check your own state's rules of professional conduct and bar rules and structure your delegation accordingly. Before we move on, I want to give you a pointer for those of you who want to go further than SMART. The framework I would point you to is OKRs, which stands for Objectives and Key Results, developed at Intel by Andy Grove and popularized by the venture capitalist John Doerr in his book, Measure What Matters. The reason I mention it here in the delegation episode is because OKRs do something SMART does not quite do. SMART tells you what a good goal looks like when you assign it. OKRs separate the objective, meaning what is to be achieved from the key results, meaning the measurable evidence that the objective was achieved. For delegation specifically, that separation is genuinely useful. The objective is what you have handed to your team member. The key results are how you and they verify at the end of the cycle whether the work was actually done. I used OKRs heavily in my prior life as general counsel inside a private equity firm and found it incredibly useful if used correctly. If you want to do a deeper dive, Doerr's book is where I would start. See the link in the description. I want to talk about this material as an attorney building estate planning practice. I came to private practice after 15 years as general counsel, again inside a private equity firm. In that environment, delegation was the air I breathed. There were teams, there were systems, there were structured handoffs. The questions were never whether to delegate. The questions were who, how, and at what level of trust. When I founded Bunn Law PLLC, I had to learn somewhat painfully what it feels like to be on the other side of that machine, to be the technician, in Gerber's language, who has just opened a business and discovered that they now also have to be the manager and the entrepreneur. I've lived inside the 70% statistic that Gerber describes. I know what it feels like to use my law degree on a task that does not need a law degree, simply because there's no one else there to do them. For estate planning specifically, this material has particular weight. The work is highly delegable once it is systemized. The intake, the drafting of routine documents, the funding workflow, the client communication. Most of these tasks fall in the lower risk quadrants of the matrix Powers and McNalis describe. The pieces that genuinely require the attorney's law degree are the planning judgment, the document review, the signing ceremonies, and the client counseling on the genuinely difficult questions. Everything else can, and in time should, live with someone other than the attorney. The piece of this chapter that I want to carry with me personally is the Percy line. The idea that an attorney can be so consumed by the work they should have delegated that they no longer have the time to actually run their practice. That is the trap. That is what this chapter is asking us to escape. I am working on implementing this and improving my practice alongside you. Here's the part of the conversation where I turn theory into something you can act on. 5 things you can do this week to put this material to work. 1, run the ratio. Pick one type of matter you handle, take a typical file, and estimate how much of the work was done by you versus how much was done by anyone else. The number itself is less important than the act of looking at it honestly. If you do not have anyone else yet, write the ratio anyway. The blank you cannot fill is the most informative part. 2, build a risk/complexity matrix for one matter type. Take the checklist from chapter 6, which we discussed in episode 8, and sort each task into one of the 4 quadrants. Then add the recurrence dimension. The result is a delegation map. You can use it the next time you bring on help, even if that help is still in the future. 3, identify your designated hitter, or the role one would fill. If you have someone on your team, name them. If you do not, write out the job description. The clearer the picture, the easier it is to recognize the right candidate when they appear. 4, if you have anyone working with you, schedule a recurring delegation meeting, 15 to 30 minutes before your production block. Create a delegation file for each person. Use a written delegation form. Review the fire forms at the beginning of each meeting. The system runs itself once you build it. 5, apply the SMART rules to one delegation conversation this week. Specific, measurable, accountable, realistic, timeline. Walk through them out loud, even if it feels formal. The act of running the checklist makes the conversation cleaner, and over time, the rules become second nature. Do those 5 things, and you will see your relationship to your own work begin to shift to a more smooth and efficient operation, and one in which you will enjoy more bandwidth to engage in additional high-value work. My personal takeaway from this material is this. Delegation is, in my view, the single hardest discipline in small firm practice, not because the techniques are complicated. They are not. The 5 steps, the 4 levels of trust, the 4 quadrants of the matrix, the 5 SMART rules. None of those concepts is intellectually difficult. The difficulty is internal. Delegation requires the attorney to trust that the work will be done by someone else, to accept that the work done by someone else will not be done exactly the way the attorney would have done it, and to recognize what looks like a loss of control is, in fact, the only path to actually having a practice rather than a job. Powers and McNalis are giving you the mechanics. Gerber is giving you the philosophy. Both authors are pointing in the same direction. The attorney who refuses to delegate is the attorney who has built themselves a more expensive version of the job they used to have. The attorney who delegates well, with the systems and the training and the tracking in place, is the attorney who has built a practice that can grow beyond them. My personal advice, again, is the same way I've left you with in the last 2 episodes. Protect your time. Guard your focus. And to those 2, I will now add a third. Expand your leverage. The first 2 are about defending the asset. The third is about multiplying. The chapter is, on its face, about delegation. But underneath the tactics, the chapter is about something deeper. It is about whether the attorney is willing to stop being the bottleneck in their own practice. In the next episode, we move from delegation to something that, on its face, sounds like its opposite. We are going to be working through Chapter 9 of Powers and McNalis' book titled Proactive Strategy 9, Take a Vacation. The authors argue persuasively that taking a real vacation is not a reward for building a good practice. It is one of the ways you build a good practice. If today's conversation was about expanding your leverage so the practice runs better when you are in the office, the next one is about what happens to the practice and to you when you're not. Before we close, thank you for spending your time with me today. I know your time is valuable. The fact that you spent some of it here on this conversation matters to me. My hope is that the information was useful to you, something you can put to work the very next time you sit down to do your most important work. If so, let me know in the comments below. To reiterate what was said at the beginning, nothing in this show is legal advice, and no attorney-client relationship is formed by listening or watching. The information presented here is general and educational and is not a substitute for advice from a licensed attorney in your jurisdiction reviewing your specific facts. The views I share are my own on behalf of Bunn Law PLLC. All references to time management for attorneys, a lawyer's guide to decreasing stress, eliminating interruptions, and getting home on time by Mark Powers and Sean McNalis, published by Atticus, are made for commentary and educational purposes only. All rights in that work belong to their respective owners. My discussion is commentary and analysis, and neither the authors nor the publisher have endorsed or affiliated with this show. I recommend everybody buy a copy. Subscribe to Estate Planning for Lawyers so you will not miss our next show. I'll see you there.